Well, shit. Here I go looking at the Kohberger case, and there's a whole lot of new documents, and that's what we're going to go over today. Guys, I'm JB Gunner. This is Crime Time. We got a lot of shit to talk about, a lot of shit to go over. Let's get into it. Let's do it.
Bring it back.
What's going on, everybody? As you guys know, I'm JB Gunner, and this is Crime Time. Now, before we get started with this shitload of documents, let me first and foremost say thank you to everybody that supports the channel. Hell, any of my channels, regardless of platform, regardless of method you choose, whether it's Cash App, Patreon, Venmo, PayPal. Truth is, guys, I couldn't do this each and every day as often as I do over the last 18 years on all these different channels if it wasn't for you, the Gun Squad. I love you guys. Thank you so much. If you too find my content valuable, feel free to hit the links down below. Join the Gun Squad, support the channel. You can also find links to my other content, man. Go check that shit out as well. Politics, gaming, wrestling, I got it all, man. Hiking, whatever you get into, you can go check it out. But anyway, let's go ahead and check this shit out because, well, we got a lot of shit. And I admit, a lot of this shit probably isn't very important. But with the true crime world kind of calming down, we got Delphi done. We got what's her name? With Quentin Simon, Leilani Simon done. A lot of people are following the illegal alien that murdered what's her name up in Athens, Georgia. I'm not following that trial. At the end of the day, it's not really important for this particular channel, because if I was to follow it, I would just follow it on my politics channel, because this is another reason why illegal immigration needs to be halted and we need to do mass deportation. But that's neither here nor there. I try not to be too political on this channel. I try to stick to the crime. So that's the reason I'm skipping the Lake and Riley case, is because I know it would just be hour after hour after hour of me telling you people that illegal immigrants suck. You know what I'm saying? And we you know, you people are kind of snowflakey over here. You don't really need that type of drama in your life. So let's go to this shit. Let's get to this shit, guys. We have quite a few, as you can see. They were all released up essentially on November 14th. Let's go ahead and get into it. The first one, order of proceeding for November 7th hearing. This was actually done on November 6th. Basically, it was just we've all seen what happened on the 7th. Basically, this is just a new documentation that was on there. It basically just said what was going to happen that day. Testimony of Dr. Wolf, if necessary, street clothing or public hearings. Public hearings closed, which clearly we saw that they let Kohberger wear street clothes. Method of execution, that was discussed. We saw all this trial, and to be perfectly honest, I mean, we saw this hearing, and essentially, they're going to still try to kill Kohberger. They're still going to try to kill Kohberger. All right, let's go ahead. November 7th, though. Let's go. Motions for permission to file exhibits under seal for hearing on November 7th. This is just them. They wanted to file exhibits under seal. Kohberger, by and through his attorney of record, pursuant to Idaho Court Administration Rule, and hereby requests permission to file exhibits under seal for the motions hearing currently scheduled for November 7th. The documents should be sealed to protect private matters. This is actually nothing major. We got another one on November 7th here. Motion for permission to file under seal documents related to the closed hearing on October 8th, 2024, which is weird. Which is really weird because I don't understand why this was filed on November 7th. Because October 8th hearing would have been a month prior to this. So this is just, I guess, just technical shit. Order for permission to file exhibits under seal for the hearing on November 7th. This is another one. The court having before it motion for permission to file exhibits under seal. So basically this is just, it's once again the same thing. The defense will provide copies for the public record. So nothing major here. Like I said, nothing major on any of these. Now we got another one on November 7th. Order for permission to file under seal documents related to the closed hearing held on October 8th, 2024, which once again, this is a month after October 8th. I don't know why these documents are so late in getting filed. Here we go. Defendant's sixth motion to compel discovery. Now we're getting to some shit. Why are we still having motions to compel for discovery? We got supplemental discovery requests. This is all still going on. All right, Kohberger, buying through his attorney of record and pursuant to Idaho code, blah, 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 moves the court to order the state to comply with the defendant's 16th supplemental request filed on August 5th, 2024. Defendant's 17th request on August 26th, and the defendant's 18th request on November 7th. These motherfuckers are still not providing all the discovery. Each of the requested items that are still outstanding are outlined in the attached sixth motion to compel, Exhibit A. Exhibit A and B will be filed conventionally, in person, and under seal on November 18th, 2024. That is today, actually. Counsel requested this motion be set for hearing in order to present oral argument, evidence, and or testimony in support of. So basically, they're still trying to get a fucking discovery. As you see right here, defendant's 19th supplemental request for discovery. This is wild shit, man. This is wild shit. Let me make sure it was. All right, here we go. Please take notice that the undersigned, pursuant to Rule 16 of the Idaho Criminal Rules, 4th and 6th, 5th, 6th, 8th, 14th Amendment of the Constitution of the State of Idaho, request discovery and inspection of all materials discoverable by defendant per ICR. We pretty much know. Constitutional provisions, including but not limited to the following information, evidence, and materials outlined in Exhibit R. These people are still asking for fucking discovery. This is wild, man. Defendant's exhibit list for death penalty motion. Grounds of arbitrariness. This was filed on, when was this filed? 11/13. So this is about 5 days ago. Comes now, Bryan Kohberger, by and through his attorney of record and hereby files with the court his redacted Exhibit A. I wonder what the fuck this Exhibit A is. We've seen it a lot. At the hearing held on November 2nd, 2024, Judge Hippler granted the defense permission to file a redacted copy of the below exhibit. PowerPoint by Professor Cover and data in support of study. Exhibit disclosures. Hold on. PowerPoint by Professor Cover and data in support of study, redacting child and sexual assault victim names. Whoa. What sexual assault victim names? And what child? PDF documents attached, USB electronic of same, will be filed no later than November 18th, 2024. That's today, due to small print created by PDF conversion of Professor Cover's study. The USB electronic file is more readable. Dated this 13th day, which makes sense. So what we got down here? This is a 50 page. This is 50 goddamn pages. Why this study? Why Idaho? Man, the cumulative effect of multiple categories on narrowing function. Idaho Code, all murder, which is perpetrated by any kind of willful, deliberate, and premeditated killing, is murder of the first degree, which we know. We get it. We get it. All right, aggravating circumstances. The defendant was... Okay, none of these are happening. E, the murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. By the murder or circumstances surrounding its commission, the defendant exhibited utter disregard for human life. That's why these things are I would imagine, is bolded. The defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. Okay, fuzzy aggravators, which we just got done reading. Gathering data Universal cases. So I'm not going to go through these entire 50 pages, obviously. I'm just going to see if there's anything here that... So this is just a study. This is just a study. I don't think there's any, I mean, I guess you could look at these things. I don't know. I don't really... So, God, that's a lot of documentation. That's a lot of documentation. What does it say? Example of narrowed statute, aggravated murder, murder of two. Okay. So is this a witness for the defense or defense exhibit list for death penalty motion? Okay. So this is essentially just all about the death penalty. You know, it is neither here nor there. Defendant's motion for leave. Comes now Bryan Kohberger, by and through his attorney of record, and hereby moves for the court to leave from the court's order governing further criminal proceedings and notice of trial setting, especially the discovery motion deadlines of November 14th, 2024. Defense counsel, and that's right, they did have the fucking deadlines. Defense counsel and investigators have not finished a full review of the vast amount of discovery in this case and will continue to do so. Counsel requests that this motion be set for hearing in order to present oral argument. By the way, I think that was denied. We'll talk about that in a little bit. All right, motion for Frank's hearing. Comes now Bryan Kohberger, by and through his attorney of record, and moves the court to conduct a Frank's hearing. The motion is made pursuant to the Fourth Amendment of the United States. A proffer and exhibits are filed contemporaneously in support in accordance with State versus Fisher. The parties stipulate to the sealing of the proffer and exhibits. A stipulation is filed contemporaneously. The under seal proffer and exhibits are being provided to opposing counsel and court staff via email. What is a Frank's hearing? What is a Frank's hearing? Let's Google that shit real quick. A Frank's hearing is a court proceeding where a defendant can challenge the accuracy of information provided by police in an affidavit used to obtain the search warrant. Okay. Essentially arguing that the police officer lied or made false statements to establish probable cause for the warrant. This hearing is named after the landmark case Frank's versus... Okay, so they're saying the cop just fucking lied. They're challenging the accuracy of the cop and the affidavit. That's interesting, right? Motion to suppress genetic information. Now, we got a lot of motion to suppress in this thing. Kohberger, now through his attorney of record, moves to suppress all evidence illegally gathered by law enforcement using his genetic information. This motion is made pursuant to the Fourth Amendment of the United States Constitution. A memorandum and exhibits are filed contemporaneously in support under seal. This motion is being filed under seal pursuant to the Honorable John Judge's previous order stating that pleadings related to this motion be filed under seal until the court could review the issues and arguments filed. The under seal memorandum and exhibits are being provided to opposing counsel and court staff via email on the date of this motion. Hand delivery to court for in-person filing will occur no later than November 18th. That's today, 2024. So they're saying that they want the whole genetic shit tossed out. That's not all, though. Motion to suppress memorandum in support. Amazon account, federal grand jury subpoenas and warrants dated April 26, 2023 and May 8, 2023. Kohberger, by and through his attorneys of record, and submits the following memorandum in support of his contemporaneously filed motion for an order suppressing all data found by law enforcement from its search in the Amazon account. Okay, now I'm concerned. Because, all right, why would you even care about that data being suppressed unless that goddamn knife is there? Do you see what I'm saying? Like, why would you, like, that makes me feel like the knife, he did get it off Amazon. The motion and documents in support of Franks versus Delaware hearing are hereby incorporated into this memorandum. So they're doing the Franks thing here. The proper with supportive documentation regarding Franks are filed under seal. For that reason, they are not set forth in full detail here, but instead are incorporated. Mr. Kohberger has a privacy interest in his Amazon account information. Holy shit. A privacy interest. Requiring information that requires a warrant. What the fuck? The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. The affidavit submitted in support of the application for the issued search warrant included information that must be excised. All information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic So they're going to try to get rid of all the arrest warrants because the genetic genealogy was done. You know what? If they actually get that through, that destroys the whole case. If it is determined that they got that DNA wrongly or illegally, that kills the whole case, right? That would mean every single search warrant that they have, like for Amazon, like for Google, because that's what a lot of these motions are. A lot of these motions are motions to suppress these search warrants, right? So this is wild, unless nothing in the warrant should remain. Information gathered about Mr. Kohberger via previous invalid warrants must also be excised. Facts. Pennsylvania law enforcement, along with officers from Idaho and the FBI, raided Mr. Kohberger's parents' home on December 30th, 2022, and arrested him. At some point, an FBI agent subpoenaed Amazon records belonging to Mr. Kohberger's account. On both December 30th and January 27th, Amazon responded with records showing Mr. Kohberger's purchases, perhaps recognizing that subpoenaing Mr. Kohberger's records was a violation of Idaho Constitution. Detective Mowry of the Moscow Police requested a warrant for the same information, telling the court that an unnamed FBI agent had located requested information. The warrant was amended due to a date error and ultimately issued. So they got the information before the warrant? Oh, you got to throw this shit out. You got to throw this shit out. The affidavit for the warrant was signed by Detective Mowry, Exhibit A. However, most of the information in the warrant was cut and pasted from an affidavit originally bearing the signature of Moscow Police Department Sergeant Blaker. But according to Mowry, now the sworn statement of Corporal Payne. Oh, the basic facts Mowry used to support the search beyond the arrest warrant facts were very minimal. A vague reference that an FBI special agent located an account for Kohberger. Amazon provided order history regarding customer email brianchristopher1994@gmail.com. How the agent located this was not explained. Investigators know that Amazon holds records for identifying devices the customers use to access their accounts, all linked accounts, other items customers have searched, clicked on, placed in cart, and viewed and saved. Who or how the investigators know this is not explained. A little information about how Amazon collects and holds data was explained. Number 4, the time frame, March 20th through March 30th, and November 1st through December 6th were selected. Mr. Kohberger has a privacy interest in his Amazon account information, this is the argument, protected by Article 1, 17.7 of the Idaho Constitution that requires a warrant. So they got this information without a warrant. Both the Fourth Amendment and Article 1, 17 protect people's interest in privacy. A person challenging a search has the burden of showing that he or she had a legitimate expectation of privacy in the item or place searched. Rawlings versus Kentucky, blah, 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 that involves two-part inquiry. Did the person have a subjective expectation of privacy in the object of the challenge search? And number 2, is society willing to recognize that the expectation as reasonable? The Fourth Amendment has generally refused to acknowledge that individuals have a privacy interest in records held by a bank, relying on third-party doctrine. This despite the fact that laws required such records to be maintained for the purpose of criminal investigation. Unsurprisingly, the federal Congress responded negatively. See Rights of Financial Privacy Act of 1978. As this court is no doubt aware, the third-party doctrine holds that information shared with anyone whom does not have a recognized evidentiary privilege is free for the government to take without a warrant. To put it another way, the third-party doctrine insists, as a matter of law, that you should trust your secrets to no one. Idaho has taken a somewhat unclear approach to third-party doctrine. The court permitted protected health records to be provided to the government. In State versus Cluss, the court did the same for billing statements from a utility company. Okay, so these are just different cases. Idaho is not the only jurisdiction to have trouble with third-party doctrine. The United States Supreme Court has refused to apply it both to the search of cell phones and the use of cell sites. The issues the United States Supreme Court take with third-party doctrine is its most recent decisions seem to be the scope of the information available to the government without a warrant if one follows it closely. The concern was first fully articulated by Justice Sotomayor in her concurrence in U.S. versus Jones. It is difficult to square this concern with what the court decided in Miller, because its third-party doctrines defender, Professor Kerr, puts it, and I don't need to read all that. In Idaho, on the other hand, the court in Thompson determined with relatively little analysis that Idahoans expect privacy beyond that in the United States Supreme Court had provided for the people they call. In essence, the court, without much explanation, held the dissent in Smith versus Merritt. However, it remains that by adopting the dissent from Smith, the Thompson court adopted a rationale for rejecting the third-party doctrine. From Justice, I'm just going to say this. I feel like this is not good for Kohberger. I understand it is if they went searching without a warrant. Bro got that goddamn knife off of Amazon, didn't he? Bro got that knife off of Amazon, man. I can't be the only one seeing this or thinking this. And remember, I think Kohberger, for the most part, is innocent. But shit like this, like why does secrecy needed for the Amazon account? Unless he bought a K-bar knife off the Amazon. Oh, man, I don't know. Let me see if there's anything else here. They're just going through cases, and that's fine. They're just going through Constitution and cases. Basically, this is all about privacy. That's what this whole thing essentially is, which makes sense, right? A lot of technical legal jargon. That's pretty much all this is. All right, number 3. The affidavit submitted in support of the application for the issued search warrant included information that must be excised. All information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy. Mr. Kohberger has argued in a separate motion that the genetic genealogy investigation in this matter was done in violation of the Constitution. Additionally, he argues that there would be no investigation into him without the original Constitution violation. And that makes a lot of sense, right? It is not the results of the IGG sped up the investigation. Instead, they focused the investigation on Kohberger, a person whose only connection to the case was his mode of transportation and the shape of his eyebrows, to identifications of little to no value. As the Idaho Supreme Court has explained, while the initial burden is showing the factual... You know what? Kohberger's probably going to... he's got a good point. The state cannot make this showing. Without IGG, there is no case. No request for phone records, surveillance of his parents' home, no DNA taken from the garbage on his driveway. In a gated community under garbage collection ordinance. I knew that trash. I told you motherfuckers back then. They illegally got that DNA. You cannot go on this people's property and get the goddamn DNA. In a gated community, on his property, in his driveway, that's not sat out for a collection. You got it. You went on his property to grab this shit. I told you guys back then. I guarantee, and I'm gonna be honest. This collection of the DNA may be exactly what gets Bryan Kohberger out of this. It has to. Like, it's an illegal search and seizure. You have a Fourth Amendment, ladies and gentlemen. You have a Fourth Amendment. Because the IGG analysis is the origin of this matter, everything in the affidavit should be excised. Separately, the information gathered via the various other warrants should be excised for the reasons set out in the other motions to suppress. Mr. Kohberger requests this court suppress all evidence obtained by police via the subpoenas and warrants that permitted them to search his Amazon account. As explained above, a warrant was required to search his account, and the warrants used lacked probable cause as written, given its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate to draw its own conclusions. And because the warrant omitted exculpatory information and information that put into question the reliability of facts upon which it relies, and finally because the affidavit relied on evidence gained in violation of the Constitution, all in violation of the Fourth Amendment. Yes. Yes. So then we move on to the next one. Motion to suppress the search warrant for the defendant's apartment. They're using the Frank's defense on all of this. Issues. The court should apply Idaho's exclusionary rule and laws to the search. Number 2, the affidavit submitted in support of the application for issue search warrant. So this is basically the same argument. This is the exact. So this is all the same argument. This as well. Every last bit of this is pretty much just, yeah. But we'll take a look at some of this. The basic facts Payne were used to support the search were next to the body of Madison Mogan was a tan leather knife sheath. The Idaho State Lab later located a single source of DNA. Footage from the King Road neighborhood showed what police suspected was the vehicle of the killer. This white sedan lacked a front license plate. A vehicle specialist decided based on the footage that the vehicle was a 2011 to 2016 Elantra. So they pretty much lose now. Okay, so witness Dylan Mortensen indicated that the height of the person she saw at the time was 5'10" and 6, bushy eyebrows. Police determined Mr. Kohberger fit that description. Records from August 21st traffic stop. Kohberger was the driver of the white Elantra, okay, lacking a front plate because he had Pennsylvania plates. Okay. It also showed his phone number and what it was. Mr. Kohberger changed his vehicle registration to Washington on November 18th. Cell tower records did not show Kohberger was in Moscow at the time of the murders. In law enforcement's experience, however, people committing crimes typically turn off their phones, they said. Historic cell phone location was obtained and given to cellular analysis cast with the FBI. Okay. So we know about the phone. So these are all the information, obviously, in the search warrant. Argument. This court should apply Idaho's exclusionary rule and law to this search. The first question the court must determine is whether there is a conflict of laws in this matter, whether Idaho law or Washington law controls the validity of the search warrant for Mr. Kohberger's apartment and necessary relief. Unlike the issue of arrest warrants, cases involving multi-state investigations have produced far less case law. In fact, the defense could not find a precise case on point for the state of Idaho. The issue, however, has received some attention in academia. Professor Kerr argued in his article for Harvard Law Review that the jurisdiction where the crime occurred should control how the investigation is done, which makes sense. But that states or federal government should provide some form of authorization to each other to participate in others' criminal investigations. As it stands, there are at least 5 different approaches to the increasingly common situation. All right, so this is just about essentially jurisdiction and essentially the apartment search. And of course, they're going to talk about the Fourth Amendment, basically the same exact reason. They're going to talk about the Fourth Amendment, obviously, that it was violated with that other shit, which is exactly what this is all saying. It goes back to the IGG. Conclusion, Mr. Kohberger requests this court suppress all evidence obtained by the police via a warrant that permitted them to search his apartment. As explained above, the warrant lacked probable cause as written, given its heavy reliance on conclusions reached by law enforcement without the details necessary. Okay, basically the same exact thing in the last one. So they're really shooting for that Fourth Amendment defense, right? Now we have this one, which is suppression, Apple account, federal grand jury subpoena, and search warrant. Oh man, this is another 20 pages. Issues. Mr. Kohberger has a privacy interest in his Apple account information, protected by Article 1, Section 17 of the Constitution, requiring a valid warrant. It looks like they're going to have the exact same defense on all of this. Yeah, this looks to be search warrants fail to command law enforcement to search the Apple account or contents of iCloud. So it looks like they're going to have the same shit here. I think that's pretty much exactly. Which accounts are Kohberger's. Basically, this is all based on the information in the affidavit. And it goes back to privacy. Nothing really here. I mean, obviously, these are going to be very basic because it's the same defense on all of them. This is all going back to the genetic genealogy. That's what this whole thing is doing. So I think that's essentially what we're going to have in all these documents, every last one of them. Let's check. All right, arrest warrant. The arrest warrant in general. They said they should get rid of the arrest warrant in general. And it's going to be the exact same reason. Information taken from the client's locations, phone must be excised due to gathered from an invalid. So the entire argument here is basically the Frank's defense, and it's everything is invalid. All the warrants for arrest, the warrants for everything. I think that's where we're at here. Motion to suppress AT&T first warrant. Okay, the phone, yeah. So this one will be about the phone. This is another 19 pages. But it's all the same shit. They're just going back through case laws. That's all this shit is. Now they're saying they shouldn't be able to. It's the same exact argument. Moscow Police Forensic Lab warrant. So they're basically wanting all of these warrants, every last one of these warrants thrown out. Which makes sense, because if they're saying that they were gained illegally, Google warrants, basically Google warrants. So, yeah, I mean, it's pretty simple. I actually think that they may have pin trap and trace device. I don't even know what the hell that is. But it's all the same. Everything, basically, they think every warrant should be thrown out because the genealogy, because the DNA was gathered incorrectly. Search warrant for Mr. Kohberger's person, his physical body. Pennsylvania search warrant for Mr. Kohberger's person. Once again, same thing, physical body. Pennsylvania search warrant for the white Hyundai. Once again, it's going to be the same thing. For the house and the statements made. Yeah. So basically, order denying motion. Okay, so the court, before the court is defendant's naked motion for leave on November 13th, in which he seeks relief from the discovery motions deadline of November 14th, 2024, as set forth in the governing schedule. Defendant asserts his counsel and investigators are still reviewing the vast amount of discovery in the case and therefore needs additional time to file motions related to discovery. Motions to enlarge a deadline filed on the eve of the deadline are not well taken. The state's discovery deadline was September 6, 2024. Defendant could have ascertained far sooner whether the discovery motion deadline would pose a difficulty and brought it to the court's attention. However, further and importantly, defendant has not demonstrated with this filing good cause to enlarge the deadline. He has not set forth what effects would have been made to review the discovery, what portion of discovery is not yet reviewed, why it is not being reviewed, or how long it will take to complete such review. Consequently, his motion is denied. They denied that shit. Yo. I don't know. I guess the big question in this case is, did they get that DNA illegally? If they got that DNA illegally, you have to... Look, man, the Constitution is the Constitution. If you violated Bryan Kohberger's Fourth Amendment rights with an illegal searches... Look, man, cases... People get off on cases all the time due to a technicality. And I think that if that's the case, he should get off due to a technicality. If the search warrant wasn't legal, the arrest wasn't legal, none of the shit's legal... And that's the bottom line. As the FBI, police, whatever, you gotta follow the law. And if you don't follow the law, there's no reason to bring this man in front of a jury. It's that simple. If you obtain this through a legal search and seizure, you have to dismiss this case. There's no other way around it. I understand there's 4 dead motherfuckers, but it does not, just because there's dead people does not mean Bryan Kohberger does not deserve his constitutional rights. At the end of the day, all of the motions were for illegally obtained warrants because the initial DNA that led to all this was obtained illegally. And I'm sorry, if you take the DNA out of this case, you have nothing on Kohberger. You have nothing on Kohberger. And I'm not even sure about the DNA you do have. But do you see my point? I think at this point, if it's true that this DNA was illegally obtained, you have to dismiss this case. You have to. You cannot go forward with this when you violated the man's constitutional rights. And look, you could be mad about it, but like I said, people get off on technicalities all the time. But the technicalities have to exist. It's what keeps our government from being, well, like the Delphi government. Let me know what you guys think, man. There's a lot of emotions, and I think Ann Taylor's got a point. If that DNA was taken illegally, what do you guys think, though? If you guys like what I do here and you find my content valuable, feel free to hit the links down below. You got to follow the rules, man. Got to follow the rules.